Asare, I do not hasten to proclaim that I have apprehended with despair the majority's conclusion in this suit, but I state with utmost deference to the Honorable Chief Justice and the rest of my brethren in the majority that not only do I fundamentally disagree with their conclusion, I, with all due respect, also find the decision an aberration to the established and accepted judicial position of this court, which, with profound respect, I hope in no distant future, the resultant usurpation of the constitutional prerogative of the High Court, incidental to the majority decision, will be reversed. What is Justice Amadou Tanko saying? Your microphone, sorry.
Yes, colleagues, on the bench, especially the majority.
Okay.
That we have the very well established rule or principle of law based on judicial precedents that if the Supreme Court speaks, it's final until they change their stance in accordance with Article 129, Clause 3.
Okay.
That's all that he's saying.
Right.
Now, he's also saying that, as far as he is concerned, on this occasion, the Supreme Court didn't have the requisite fundamental or foundational jurisdiction to embark upon the journey of discovery that they, permitted themselves to make. That's why he fundamentally disagreed with them.
Okay.
Now, what are the facts that will anchor what Tanko Amadou JSC permitted himself, to observe? One, we have the scenario occurring as of the 15th day of October. So a fund or relief sought.
Okay.
So if you go to court to ask for something that is not there, you should be non-suited. On the 15th of October, the Speaker's Act complained of, which is the communication or the vacancy or the 4 seats, are not okay. That act purportedly arose on the 17th when, he made the communication, which we are interpreting to mean the ruling or the declaration or the
So in essence, Mr. Asare, what you're saying is that when Haruna Idrisu mounted the stage and hinted that 4 MPs were in trouble, Afenyomakin then goes to court to say, I want an interpretation to this. Yeah. You're saying that it was premature for Afenyomakin to have.
It was premature because all of us needed to wait for the Speaker's
ruling
or
decision, or however you want to call
whatever.
it, or pronouncement.
Whatever. On the 15th, the Speaker had not spoken.
So what did you take to court?
What did you take to? So Afenyomakin's rate was founded on nothing. And our law, our jurisprudence is that you cannot put something on nothing and expect it to stay there. It will collapse.
No, but sorry, again, excuse me here. You are seeking, because you are invoking the interpretative jurisdiction of the Supreme Court, which is its original jurisdiction, isn't it?
Sure.
So my point is, must you wait for an action to have occasioned before you go to the court and say, well, I've been reading the Constitution. There's something I'm not too clear about. Please help me understand it. Must you wait for something like that to happen? Yeah. Or you can, any ordinary Ghanaian can go to court and say, I want to understand this clause or provision in the Constitution.
Yeah, so the provision in the Constitution, that grants the citizens the opportunity to take any matter in controversy to court.
Yes.
It's encapsulated in Article 2, Clause 1.
Okay.
That's why we're a person who alleges.
Oh, okay.
What are you alleging? What are you alleging?
Okay.
Therefore, there must be something, on which you can anchor your allegation that there's an infraction, not that there is going to be an infraction.
Oh, I've heard.
No.
You don't do that.
The law doesn't act
so
like
the
that.
court shouldn't have entertained Afenyomakin's suit?
No, at all. That is where that you're sorry.
Oh, he's raising issues.
Is explaining that, you see, on the 15th, what the plaintiff or applicant had come rushing to you to complain of hadn't arisen.
Okay.
We in law, in injunctions, we have what we call the quiatimate injunction.
Okay.
Quiatimate because we are apprehensive of something occurring, of some threat to you, so you can go to court. But there, that threat, should be captured in something that may be the construction of a building, or you say, but here, this is a constitutional matter in which the applicant is saying, look, I've come to you. If you don't help me, something, is going untoward will happen.
Okay.
What is that? So if the Supreme Court justices had, posed the question, what is it that you are complaining of? I don't know.
Haruna Gisu said.
No, that is what the applicant is saying. I don't know.
And I get it. But the point I'm trying to say, the Haruna Idrisu statement cannot be a cause of action.
No.
Oh. No. So if there's no cause of action, at the time the suit was filed, the Supreme Court had no business listening to him.
No. Because what will trigger the cause of action will emanate from the Speaker's remarks.
I see. So please go ahead.
Yes.
So I wanted you to tell me your understanding of what Justice Tanko is saying.
Yes, so Justice Tanko is saying that majority, but I must say that the majority, the concurring opinion, the dissenting opinion, all three are fantastic.
Okay.
Fantastic, very refreshing. For once, we didn't have, a sensational headline. Supreme Court bounces. For once, we have, we don't have a unanimous, but we have judicial minds espousing the law, telling us where, and it's a reminder that yesteryears we did have the judges who could deliver themselves of, what the majority, the concurring, and the dissentient delivered. Great judgment.
I see.
Food for thought. Whether we may not like the conclusions, but let me try to situate the problem that confronted the Supreme Court.
I get it. But before you go ahead, I thought, when I was reading the Justice Tanko's thing, there was a portion where he said that the court is not a court where academic or fanciful issues which are not live are dealt with.
Sure.
It is based on what you just said, which is there was no cause of action. So what did you file in court? So that's what he meant.
Sure.
Okay. So go ahead.
So if you are sitting, if you are a sitting judge, please, don't put your ears to the ground. And listen to what the law teachers, the law students, the legal, politicians, but you have a life matter in your hand. What is the position of the law?
That's all.
That's Tanko's approach.
Okay. So you're trying to set a context.
Yes.
Before I go to Hamza and
yes. So the issue is this. If you look at the rate, what was the plaintiff asking the Supreme Court to do? Now, Asare, who spoke for the majority, if you look at page 2, the first paragraph, which is the concluding, remarks of the first, last paragraph, page 1.
Yes.
He made it quite clear that on the 17th, when the Speaker's conduct or act complained of arose, these people had already, commenced the action on the 15th. That is where he himself, as well as the majority, had a problem. You have come to us. What is your, prayer? The prayer must be grounded on something. That something was not there. So they kept struggling to find that something on which to anchor their conclusion is not there. Therefore, when we ask ourselves, did the majority make any consequential orders? Consequential orders on what? They couldn't have. They simply could not have made any consequential orders.
So there should have been an amendment to the rate?
They should have thrown, out the plaintiff.
The plaintiff.
Because the rate was not even accompanied by, under the rules, it should have been accompanied by an affidavit verifying the facts alluded to, in the statement. There was no such rate. So it was incomplete. If it was incomplete, the jurisdiction of the Supreme Court couldn't have been properly invoked.
I see.
Number 2, under the Constitution, the Speaker ought not to have been joined. He ought not to have been sued at all. If you sue the Speaker, it is the Attorney General who must constitutionally
defend
it. Therefore, when the suit was commenced against the Speaker and the Attorney General, the approach of the Supreme Court should have been, well, applicant, we realize that you have added the Speaker. Are you aware that constitutionally it is only the Attorney General who can defend unless we grant leave joining the Speaker, and then the Speaker will become a party properly joined to the suit? The Supreme Court did not do that. The Supreme Court rather hastily accepted a writ on its face as though it was a writ properly filed. It wasn't. So I have a fundamental issue, there. If the Speaker, if the Attorney General is to, which it is within his province to state that I am the defender, why bring in the Attorney General? He's right. You see, so there again, it was fundamentally defective.
Okay.
So it created a situation where you brought a party who had been improperly joined to the suit. And if you look at the majority opinions, we're all grounded. The first speaker said this, the first defendant said that, the first defendant said that. When the first defendant came to court on the 28th, the affidavit in support, of the application to dismiss the suit, we're all wrong. Because they were attacking a party who was non-existent. They were attacking a party who was non-existent.
Party.
No.
To the suit.
No. It's only the Attorney General. Now, the question is, on the 15th...
The Attorney General then became a second defendant to the plaintiff.
Yeah, but the first defendant was improperly joined.
Okay.
And Article 88, Clause 5 of the Constitution, it is only the Attorney General who shall defend suits against the state. And the Speaker is part of the state. Period. Now, when you have, that kind of problem confronting you, what do you do? Procedurally, the Supreme Court has every right to order the Speaker to be properly made a party.
Okay.
Seeing the potential conflict of interest, if the Attorney General were allowed to represent the Speaker, there's a potential danger, and it's a threat to our democracy. Therefore, the Supreme Court will say, well, Mr. Attorney General, let's begin with the plaintiff. Plaintiff, we have looked at your application for stay of execution filed on the 17th. Well, we are unable to consider and grant, your relief today.
Okay.
Please, it is ex parte. It is without notice to the other side. The person, you have notified, the Speaker, is not the person, who should have been attacked by the plaintiff. Therefore, we are going to make an order that the applicant should bring the defendant to court, that is the Attorney General, on notice.
Oh, okay.
Without granting any 10 days or 100 days or no, they shouldn't, because the rules, under the rules, when the application comes for hearing, the court will do one of several things: either grant or refuse,
okay,
or give set directives as shall conduce to justice, as the justice of the case requires it. That's what they should have done.
Okay.
They didn't do that. That is why Sorry is saying that when you look at it, fundamentally flawed. The facts were wholly unmeritorious. Why were they wholly unmeritorious? Because the act that occurred on the 17th hadn't occurred on the 15th. So factually, it was without merit. If the writ was not accompanied by the affidavit of verification as required by the Supreme Court rules, then it meant that it was incompetent. The Supreme Court had an incomplete process on their hands. So what the Supreme Court should have done was, look, go and put your house in order. We cannot accept it as it is. Now, putting their house in order necessarily meant curing the deficiency. And what was that deficiency? that the rate did not contain any reasonable course of action. Don't blame them. On the 15th, the course of action hadn't arisen. But on the 17th, when the speaker made a communication, that triggered the course of action. Therefore, as of the 17th to date, the applicant or the plaintiff should necessarily have amended the rate. As we speak, they never amended the rate. So the Supreme Court had a defective rate on its hands. Why then did they proceed? Because as a law teacher, and this is a fantastic judgment for law teachers and law students, because we have a lot to engage our students on.
As far as this judgment is
exactly. Were they right?
But if you listen to the Chief Justice and her concerns and worry that Parliament is not sitting, can you now understand why we had to sidestep a few of these things? Just we want to hear the matter. The technicalities can wait. The Chief Justice told us that she's concerned that Parliament is not sitting.
Yeah, but it must be according to law.
Okay.
Whatever the Chief Justice is, it must be according to law.
Okay, I get that.